Thank you, everyone. Please be seated. We're here this afternoon for our third and final oral argument, Northwest Bank and Trust versus Pershing Hills. Looks like both parties are ready. Mr. Russell, you may begin.
May it please the court, counsel, one vague sentence in an agreement to agree should not be carved out of that agreement to create an exclusive right to be the lender on a project in perpetuity for the bank. Such a carve-out of an agreement to agree puts the borrower at the complete mercy of the bank in perpetuity. Those things are inconsistent with Iowa law, and they are inconsistent with public policy. The district court got it right, and the Court of Appeals committed error, and this court should overturn the Court of Appeals and reinstate the district court's opinion and the jury's verdict. There are three key things. One, the sentence that purportedly creates this exclusive lending right, perpetual in perpetuity, is too vague to be enforceable on its own. Two, the bank's interpretation saying we've got this exclusive right to be the lender puts the borrower at the mercy of the bank. That is specifically inconsistent with Iowa law, which says that a contract shouldn't put one party at the mercy of the other.
Is it possible, I've kind of reread the Court of Appeals opinion a couple times, that maybe what it says is something more limited, which is, could there be an agreement on the exclusivity provision, and that's it, and then the measure of damages would be the cost of due diligence? As I'm reading the file, it seems like there's some confusion on the agreement. I mean, you would agree that the exclusivity provision could be enforceable in that respect, right?
Not this exclusivity provision. I think that if the parties were to draft an exclusivity provision that said, while the parties are engaged in specific due diligence tasks, then there's an exclusive lending relationship. Then the bank is entitled to the exclusive consideration of being the lender, that the borrower is not going to shop it anywhere else. But that's not what they did here. This was this provision is wrapped into a proposal on terms, and it doesn't specifically say that the exclusivity runs during the period of due diligence.
Acceptance below assures Northwest Bank of Pershing Hills exclusive consideration as lender in exchange for the expense and time and travel of the proposed due diligence. I don't know. I've looked at a lot of contracts. That seems pretty clear.
It says that of the proposed due diligence. So I disagree that is definite enough in terms of time period. If they said, while we're engaged in proposed due diligence for the next 60 days or 6 months, okay, then it's got a definite enough term.
Mr. Russell, this is not an uncommon thing. You have sort of a term sheet between two sophisticated entities like here, and then there may be some and the term sheet is not a final deal, but there's some language that says, during the time period we're going to agree not to solicit each other's employees, or we're going to agree not to look for other partners to do this deal with, or something like that. So what's wrong with that sort of in the context of a general agreement that's probably not enforceable, having a specific provision that is?
And I'll try to answer both of your questions with this. I think in general that's possible. Here, I disagree that it's definite enough to do that because the due diligence isn't defined in this specific instance. But if you look at the list of due diligence elsewhere in the agreement,
On that, I mean, due diligence is a term of art. It's known by lawyers and sophisticated parties. We know what due diligence is. We know what the process looks like. Whatever industry you're in, due diligence kind of runs the exact same way. Wash, rinse, and repeat. I don't know. I mean, do you really think there's a fact issue about what due diligence is and what that means?
one, due diligence can cover all manner of sins, right? Like parties can say, well, this is part of my due diligence to get comfortable with this transaction. In this case, the parties specifically listed out the necessary due diligence in the proposal, and it listed several things that needed to get done, including state tax credit award letter with a list of imposed conditions, federal historic tax credit, Part 2 approval with a list of all imposed conditions, and Grayfield tax award documentation. And so those Grayfields were never awarded. And so if this court wants to say, hey, this exclusivity was in effect during the proposed due diligence, then okay. But then we got to go back and look at the list of proposed due diligence items. And once one of those conditions fails, the Grayfield tax credits were not awarded twice, then the exclusivity provision would necessarily end. Otherwise, according to the bank's own testimony, the bank said, I was under no obligation to, Mr. Slavens testified, I'm under no obligation to do anything. I'm under no obligation to actually lend any money. The bank could then tie up the due diligence forever, for 6 months, for a year.
This way, somebody could have just said, hey, we are considering other lenders now, so we'll pay you for your time and expense in doing the due diligence that you've done up to this point. Problem solved. I mean, that seems to me to be what the contract says.
If the contract had said that, yes, but that ignores the email from Mr. Slavens, who presented 3 options to the borrowers, which were 1, kill the deal, 2, come up with another $160,000 in equity for each partner, or 3, pay me a sum of $75,000.
Or argument. It seems to me, rather than just saying this exclusivity is not enforceable at all, I mean, maybe the better reading is there's sort of an implied condition that it's exclusivity as long as what's on the table is the deal that's here. As soon as the bank changes the deal, well, then, that there's sort of an implied condition of the exclusivity has failed and gone away.
I'm not likely to disagree with the justice who says my better argument is something. So, yes, I agree with that.
Up on that, what are we to make of these statements about, the fact that the Grayfield tax credits were maybe still out there, still being pursued? Was the deal really dead after this December 11th email? Or, was there a possibility that these tax credits were maybe still going to come in, meaning that this due diligence period was continuing on?
Your Honor, I think the issue is that there's always the possibility of being able to continue to apply for something, right? So there has to be an endpoint at some point for a contract and for an agreement. And what better endpoint is there than when the lender says, kill the deal? And that's part of the record. The testimony says, the testimony was, Mr. Slavens believed when he said kill the deal, that meant the project was dead, period, that nobody could go forward with it, and that it was just over. Whereas Mr. Carroll and Mr. Ruhl said, this settlement proposal, or this lending proposal with this bank was over. And so, both parties agreed that it was time to end at that point once the Grayfield tax credits didn't come through. because the fundamentals of the deal changed, right? Like, once you ask for an additional $75,000 fee or an additional $800,000 in equity, then the fundamentals are completely changed, and there has to be an endpoint to allow for the free flow of commerce. Otherwise, the bank can continue to say, well, you got to reapply for those Grayfield tax credits every single year, and then the bank can say, you got to keep doing it, and the exclusivity provision continues in force and effect for as long as the bank decides, I want you to do that, even though the bank has said, I didn't have to do anything. I didn't have to propose any lending terms. I didn't have to go forward at all. And so I think that's as Justice Mansfield, as you pointed out, there's the condition precedent, right? Like that if the court is going to read a term into this, which is, the proposed due diligence time, there has to be an endpoint at a certain point. And the parties undertook to list when those would be, and that's the proposed due diligence in the agreement. And I think it's important to keep in mind that this proposal was put forth by the bank. The bank drafted it, so it's construed against them. That's axiomatic. And then two, this is just an agreement to agree, and those in general are not enforced. And so we're doing some mental gymnastics already to get there. But then the second issue is that this really puts the borrower at the mercy of the bank. And that is fundamentally unfair, and it has the potential to really bind up commerce. Imagine a case where a car dealer wants to put an agreement forward to people that want to come in for a test drive, right? Say, hey, if you want to take a test drive, you're not allowed to talk to anybody else about a price on a car or lending terms. You have to deal with us.
That may be true in a consumer circumstance might be a problem, but don't our cases say that if the terms of a contract clearly require it, it is okay for a contract to put one party at the mercy of the other, and in a commercial circumstance where they're able to negotiate?
This isn't a contract. This is an agreement to agree, so I don't accept the premise, but go ahead.
There's a contract nestled in there.
And two, you can to a certain extent, right, as long as it's negotiated, but there's no evidence that this was negotiated. This was, the bank put this forward and said sign it. And so I think there are limits to how much you can put somebody at the mercy of another party, especially, and we briefed that, especially when the risk is this obligation, this indefinite obligation. I would concede that if there was, a 60-day time frame or a 6-month time frame within the language, right? If you just carve out the sentence that Justice McDonald read to us, if you add for the next 60 days or the next 6 months.
It's normal in contract law. I mean, you would say for a reasonable period of time. I mean, to me, it reads like contractual language. Acceptance below assures lender. Again, I think the better argument is what are the conditions that are associated with this exclusivity, and does it include some notion that the bank has to be actually working on the deal that's contemplated in the agreement?
I agree with that, and Your Honor, that's not what it says, though. And so we're adding in terms, and I agree that if we're going to add in terms, then we've got to go look back at the.
It's part of an overall document that says proposed financing, and then it talks about proposed due diligence, which is for the proposed financing for the proposed deal. So, I mean, I think your client would have made it easier if they had just communicated with the bank and said, since you're not intending to continue with the deal, we're going to go ahead and look at other sources of financing.
Your Honor, but there's no obligation to do that. As Justice May pointed out, this is a commercial transaction. In a commercial transaction, there's no obligation to tell the other side what you're doing. If absent some contractual language, you're entitled to. There's no fraudulent inducement in a.
Or unless you have a provision that says you have the exclusive right for a while. I mean, so what do you do with that?
Your Honor, but here, the condition preceding had failed. The Grayfield tax credits hadn't come through, and so we're.
Mediation, and you don't convey to the other side that, hey, we really think you've repudiated. As far as they're concerned, you're acting like the agreement is still in effect. What's their alternative?
I'm out of time, Your Honor.
Answer.
If I understand your question, I think you're asking, what's the bank's alternative if we're telling them? What's our alternative?
What's the bank's alternative? They don't know that you viewed the conduct as a repudiation. Instead, as far as they know, you're okay that they're proposing to change the deal. You still view the agreement, so to speak, as in effect.
One, I'm not sure that's the case here because we have the email from the bank saying, hey, kill the deal or these other things. So I think that's a fair demarcation in time. Like, why can't the lender take the bank's word for it that they're killing the deal? And two, I'm not sure there's an obligation under Iowa law in a commercial contract setting for people to communicate those things. One, absent an enforceable exclusivity provision. Thank you.
May it please the court and counsel. I think I want to start just with a very brief background on the relationship between the parties because I think it is relevant. As the Court of Appeals summarized, the bank's relationship with Pershing Hill and the defendants dated back a few years. There had been a prior financing proposal about a year prior to the agreement or proposal that we're talking at here. And so it's not at all surprising, yet I think several of the justices have mentioned we see these types of terms in commercial contracts. For the bank to say, okay, guys, we'll work with you here on diligence, but we want some assurance we're going to be the only party that you're working with during that time. And that's what we have here. We had offer, we had an acceptance that's very clear, and the duties, I think, are very clear. The issue that seems to arise from the defendant's perspective is the durational term. And I think the language of what I'll call the exclusivity provision provides that inherently, that acceptance below assures lender of borrower's exclusive consideration as lender in exchange for expense in time and travel of the proposed due diligence. So plainly, there's a limitation that assumes the exclusivity that's been agreed to will be in effect.
Kill the deal. It didn't say accept the exclusivity. The deal. Isn't that the whole ball of wax?
Mr. Slavens testified, and that was within an email that had several different options that the parties could proceed with.
Cool language. I mean, who doesn't see that as game over?
Mr. Slavens testified as means you guys aren't moving forward at all. His testimony was it's not saying kill the deal with me. It was one of several options that were being presented.
You know, if the bank had sent an email to Pershing Hill and said, you know, we're not going to do the financing at the way it's discussed here. We're going to lend you half the amount of money we're talking about. Are you saying that at that point they're still obligated to work only with the bank, even if the deal changed totally?
I think we're saying that, Justice Molson.
The argument, I mean, but that's essentially the argument. They said the email changed the deal, and then once the deal changed, doesn't the exclusivity obligation go away?
Push back on the email changed the deal. What happened is we had changed circumstances. The parties knew in October of 2015 that the Grayfield tax credit was not going to be awarded this cycle. And so, as is always, I would say, or at least often the case with any type of proposed financing, there are things that come up, things need to flex.
Options in the email. One was kill the deal, as the chief pointed out. That's pretty definitive. The other was Pershing Hill comes up with a bunch more money, or the other is Mr. Slavens gets a bigger fee. All of those were changes to the deal from what was here. So at that point, isn't the exclusivity off?
Unilateral proposed changes, right?
That's correct. Proposed. Unilateral, certainly. But I think what the record shows, and I'll get back to your question, is after the situation arose with the Grayfield tax credit situation, there was discussions for many months about ways the deal could continue to go forward. And I don't remember, without going back to the record, the specific date of that email, but that was simply one of various communications. What then continued to happen is the parties continued to try to discuss different ways to move forward, bringing in, at least from the bank's perspective or understanding.
What is the specific breach that you're alleging?
The breach here would have occurred when the record would show when the Pershing Hill, the defendants, started to reach out and work with another lender, and then ultimately when they received the financing, which
Seeking.
well, at trial, there would be several potential items that could come up. I think, Justice McDonald, you already hit on one of them, which is spelled out in the contract, which would relate to the bank's expenses, time, et cetera. Depending on how the evidence came in, the bank could potentially make a benefit of the bargain type claim under the contract as well. That would depend, on the evidence that was presented.
I'm asking. It seems like there's a little bit of confusion in your briefing and maybe in the decisions below. It seems pretty clear there's, at least to me, there's an agreement here for an exclusive period or a period of exclusive consideration for the bank as the lender in exchange for the cost and time and expense of doing the due diligence. But then on the damages side, it seems like you're saying there's a larger agreement that they had to proceed in good faith to actually close the deal with the bank. And maybe there you're losing me. So that's why I wanted to understand. I mean, you do think that some of the damages here are for the contract, meaning benefit of the bargain, lost profit in closing the deal.
On the contract claim. Certainly the time and expense that's actually spelled out here. We never had a chance to fully develop the record below, but you could imagine a scenario where the evidence shows had the defendants chosen not to, in our view, breach the contract, a deal would have been reached. It's a different question. The facts haven't been presented. It's not before the court.
Say, for example, there's a contract here and it's for a period of exclusive consideration and the only damages are time and expense on due diligence. That's fine with your client.
Disagree with that finding, and I think the Court of Appeals noted, I think correctly, that the issue of appropriate damages, if there is a breach of contract claim to be tried, is not before the court. Our position would be, as I stated, Justice McDonald, certainly it would include the time and expense element you've talked about.
Up on what Justice McDonald's been asking, but doesn't that imply that you can't just read this exclusivity in the vacuum? It has to be tied to this overall proposal. And that's when you kind of lose me, was when I see the bank in that email, offers three options, none of which is consistent with the deal on paper, that at that point an implied condition of the exclusivity has gone away.
Hopefully I understand your question correctly. Again, our position is the exclusivity continues to apply per the terms of the agreement so long as the parties continue to work on due diligence with the goal.
Maybe asking that same question a little bit differently. I mean, this is called, it is titled Proposed Financing, and the very first paragraph is Proposed Transaction, and it lays out all of the different sources for funding this. And based on that December 11th email, this proposed transaction is no more. there's some transaction, but it's not this one. And so once this one ends, I mean, in theory, your client could have gone back and said, okay, new proposed transaction, we're going to sign another one of these, but they never did. And so with your own client, putting in an email what the different transaction would be, why is this one still effectual?
And I understand your argument, and I think with that logic, you could say when the parties learned definitively the Grayfield tax credit wasn't going to be a part of the current financing scheme, at that point, the deal has changed from what's written in this document, right? And so our position is, and I think the record's clear, the parties continued to work together to try to, you can call it modify the deal. I would call it coming up with new terms to accomplish the financing goal of the parties. They continue to engage in diligence, looking for a different tax credit investor, et cetera, et cetera. Our position is in response to the argument that somehow this is indefinite or traps here the borrower. That's not the case. Either party, I think, as Justice McDonald alluded to, could have at some point taken the position and say, you know, we're moving away from this. We're not going to continue to engage in due diligence to try to accomplish the goal that we've set forth. So that's our position on responding to the...
Better than I do, but when that suggested email went out, kill the deal, A, B, or C, did you ever get a direct response, we don't choose any of the above, or that we choose number one? Was there ever a direct answer to that proposal?
Your Honor, yeah, the discussions between the parties then continued. This would be cited in our statement of the record, obviously. We got into January. The defendants were telling the bank, hey, we've retained a third party to help us find a new tax credit investor. We have an internal email amongst the defendants in April telling their third party, send Mr. Slavin some due diligence so he'll leave us alone, right? The bank's perspective was always the parties continued to engage in this process with the goal of reaching a deal. And at no point, and perhaps this goes more towards our second claim relating to fraud, at no point were they ever informed, hey, we backed off, we're moving away. It's quite the contrary.
Never work with you again? It seems to me like there's nothing wrong. If that exclusivity is gone, what's wrong with them shopping, including you again?
There would be nothing wrong in that case. I agree with you.
I might be just a little confused. So you were saying earlier that basically it would be fine for them just to walk away and say, hey, we're not going to work with you on lending anymore? That was a right that they had under this?
First of all, our position on the financing itself is the parties didn't agree that financing would be provided. On what we're talking about, I think the only way to read the what we would call the contractual provision at issue is that the exclusivity relates to the period of time that the due diligence that has been proposed is ongoing, right? And so one could make the argument that if that is no longer ongoing, then the exclusivity no longer applies. Our argument here is it continued to be ongoing throughout this entire process, which is evidenced by the conduct of the parties.
Basically, the fact that they didn't tell you that they wanted to do something different.
Tell us, but they continued to, what we would say, engage in due diligence, continued to provide us information, continued to ask us to talk to their representative, the types of things that would be going on in a potential lending relationship.
Understand how that gets you, I'm going to call it, to the bigger contract claim, that somehow you were going to close on a financing deal and get damages for benefit of the bargain, lost profit. Seems like everything that you're saying on the contract claim is really about due diligence expense. So tell me, are you making this bigger contract claim and that you want the bigger damages and that seems to be the problem? Or is it really just the cost of due diligence?
I think at trial on this claim, we would pursue both what I'll call the expense portion and benefit of the bargain damages, assuming the district court finds there's evidence to support that. That would have to be contingent, which we think the evidence will show, is if the defendants had simply followed through with us and made what happened, ultimately happened with us, it could have been that the bargain would have been received.
About the record, Mr. Bauer. So there were, under the due diligence part, there's sort of 20 items listed, I through XX. So after the kill the deal email, did Pershing to continue to be providing information in terms of any of these items to the bank?
Continued to have communications and exchange information for
Any of these specific due diligence items?
tax credits, the Grayfield tax credits. Our brief will have set forth in the record the continued communications about finding a potential additional source to be.
It's not actually in the list. The list is award documentation. There was no award. So is there anything in there? Because I could see, your argument maybe a little more clearly if Pershing is continuing to provide the information for your people to look at, and they're continuing to work on these items of due diligence.
As I indicated, there further discussion and exchange of information on the tax credit issues. There's a considerable amount, and I won't recite it all, it's in our brief, between the period of October through January of the defendants actually asking Mr. Slavens and the bank to reach out to their tax credit investor, have bank-to-bank conversations, obtain more information about this, that, or the other. So the continued work was extensive. And we've noted in the record as well that Mr. Slavens in that time period actually sent an email to the guy saying, hey, this is really increasing my cost. Do we really want to go forward? They continue to do that.
About what the agreement says. You're focusing on that sentence that says proposed due diligence. And I'm asking you, are there any of these actual items in here that your client was incurring more time working on after the kill the deal letter?
Just mentioned, Your Honor, that be recited in our brief. I'm running out of time. I did just very briefly want to address in the alternative, if the court disagrees with the Court of Appeals ruling and affirms the district court, we think the record clearly establishes the need for a new trial on our fraud claim based on the wholesale exclusion of this document from the evidence in its entirety. But I won't get into details as I am out of time. Thank you.
Thank you. Mr. Russell.
Thank you, Your Honor. One, the exclusion of the agreement was an evidentiary question that was well within the discretion of the trial court. And once it made the decision that the language in the proposed financing term was unenforceable, then it was well within their discretion to exclude it. I want to spend my time responding to some specific things that were brought up in Mr. Bauer's argument. One, he started by talking about the relationship. Not to be crass about this, but this is a commercial transaction, as Justice May pointed out. The relationship doesn't matter. This isn't about friendship. This is about two commercial parties negotiating a big contract. So one, the relationship doesn't matter. Two, we've heard a lot about the kill the deal email, and I mentioned it in my initial argument, but I want to point out the appendix page, which is 570, where Mr. Slavens testified his reference to kill the deal meant that Pershing Hill would not pursue their development project at all. And so his intent was clearly that, hey, he's in control forever, that if the deal's going to be done, then Pershing Hill Lofts can't ever come to fruition because he's the exclusive lender in perpetuity. And intent of the parties matters, and he testified. He told us that kill the deal means you can't do the deal ever. And then three, Justice McDonald, you brought up the benefit of the bargain and the damages that would be sought. I think it's important to remember that there was no bargain. There was no contract. It's very clear in the writing. It's very clear from the communication that the parties never reached an agreement on loan terms. And in fact, Mr. Slavens testified that after the kill the deal email, he never made another proposal. He never reached out and said, hey, here are some loan terms. This is what we can do to make this work, after the kill the deal email. And so
Pershing Hill continue with due diligence with the bank, though?
depends what due diligence means. We've heard that due diligence can be a term of art, and
At least I am. I don't know, maybe Justice Oxley, I'm sorry to interrupt, but I'm asking about the 20 items. The 20 items, did you continue to provide those to the bank?
to have conversations because we were trying to keep things, keep things open because the project was still trying to move forward. But the Grayfield tax credits was the last holdup, as far as I recall from the record. And the Grayfield tax credit simply hadn't happened, and so there was nothing else to do. Now, I talked about the one-sidedness of the agreement, and in the due diligence, in the 20 items, the 20th item says, other items as requested during further review. Now, that's another indication of just how one-sided this agreement is, so that this supposed exclusivity could go on forever. As long as the bank keeps asking for additional items as requested during further review, then the exclusivity can continue.
In addition to the 20 items in the due diligence, did you continue communicating with the bank as if you were continuing to try to get financing from them? And if you were, did you indicate anywhere that you were also communicating with other banks?
I don't know that we communicated to them, but the record does reflect that Mr. Slavens knew very early on, after the Grayfield tax credits, that he suspected the deal was being shopped. He testified to it. I'm sorry, I can't give you the citation. It's in our briefing. But he testified he knew or suspected the deal was being shopped. And so my time's almost up. Absent any more questions, I'm going to sit down with the request that you overturn the Court of Appeals and reinstate the district court's opinion, or the district court's decision.
The case of Northwest Bank and Trust versus Pershing Hill is hereby submitted, and court